Hello, welcome again to Business Immigration Online. This is the third part of the presentation about the H-1B visa. We're going to cover a few issues that often come up in cases where H-1B is involved. It also probably from time to time goes in the arguments that are in the public about that visa. Scope of work and location. H-1B is important to know can be full-time or part-time. The person on a part-time beneficiary can have several H-1B employments at the same time. Each of the employers will have to file a separate petition to prove that their job is indeed specialty occupation, that the control employer-employee relationship will exist, and so on. But a person can definitely have more than one H-1B employer at the same time. There are situations where an employer has more than one location. They have two offices, three offices, four offices, and the employee, the H-1B employee, is required to move between those locations from time to time or among those locations. In this situation, there might be a need to post an LCA in each of these offices and make sure that it includes the prevailing wage relevant for that area, um, and that the person will be compensated at least at that level. I just want to remind you from the reading, prevailing wage is the wage the Department of Labor determines is the prevailing payment for people in similar position in that geographical area, and that amount is the minimum that the employer must pay the employee in order to avoid a situation where um, the employee received lower wages, and as a result, wages are depressed um, in comparison with U.S. workers. So that's the reason why we have a prevailing wage. And of course, the employer, as always, will have to show that they maintain control. But oftentimes, when it's the same employer with different offices, that's not too difficult to prove. Um, Sometime an employer moves from one location to another. We have a recent decision, relatively recent decision, that stated that if the move is between the geographic zone where the prevailing wage was determined before, so for example, if an employer moved from one building in Manhattan to another building in Manhattan, that is a change that is within the geographical zone of that the LCA covers. So in that situation, there is a need to post the LCA again, the same one that was approved before, because there is no change in the wages. If they move to a different geographic location where a new prevailing wage is determined, or even if the amount is coincidentally the same, but it's a different geographical zone, then an amended petition must be filed with USCIS with a new LCA. That is the this is the holding of this decision, and it resolves some uncertainty that was in the field for a long period of time. Now it's slightly more clear. There are other situations that still remain um, not completely certain. Reorganization. H-1B employment often lasts quite a bit of time, and during that time, the employer might go through reorganization, as in mergers, acquisition, changes of the way they operate and structure, and so on. In many of these cases, H-1B employee can maintain their status and keep on working for the entity that survives the merger or the acquisition, and continue uh, essentially when the new entity assumes um, all the or most of the liabilities and rights of the predecessor of the original petitioner. So they take on the responsibilities and they take on the rights, and as a result can continue and employ the person on H-1B without filing necessarily a new petition. They do have to document and record um, all the all the steps that were taken to assure that things are done in compliance. Um, So this is good because again, in certain periods of time, the economy has extensive amount of M&A activity, and many of these employees can find themselves in a problem if they are on a visa and the visa cannot continue. And there are situations where reorganization will be fatal to a visa. We will see that there are work visas that depend on the identity of the company or the country of the company and the identity of the shareholders or on the relationship between two or more organizations. So we have this slight relief for organizational changes for H-1B employee. H-1B, like other work visa, is subject to the provision of export control. This is important because by US law, by the way, not immigration law, disclosing information to a foreign national who is not a green card holder is deemed export of their knowledge. So, if there's a scientific knowledge and that knowledge is shared with a foreign national and H-1B, that's a deemed export. Now, certain exports of certain things in the US is subject to particular rules. There are several agencies that control this, the Commerce Department, and in certain situations, the State Department, and so on. And they all have rules about what things can be exported and what not, and that include knowledge. Certain amount of technical knowledge or certain types of technical knowledge is definitely something that requires a license in order to export. So in this situation, the employer will have to get a license in order to share that kind of information with the foreign national. And the attestation for that is on the form now and has to be done with respect to any H-1B, and we will see that other visas as well. Status in the US. As you remember, a person who is a foreign national and is a non-immigrant in this country must have status in order to be here without violating or without overstaying. So H-1B, unlike the visas we mentioned before, the F1 and the J1 and the M1, is for a date certain, and that date certain is usually the end date of the petition. H-1B petition can be approved for a maximum of 3 years, and usually each admission in H-1B will be until the expiration date of the current petition. Okay? Now, that is important because if you have a date certain as opposed to DS on the I-94, if the person does not leave by that end, they start to accrue unlawful presence towards the bars for admission. While that does not happen if the person is on a DS I-94 in most cases. Now, in terms of calculating the 6 years of admission, it is clear now, based on decisions from the Administrative Appeals Office, the only time spent in the United States in H-1B count toward the 6 years. That means that if there are H-1B employees who travel extensively internationally, they might be able to recapture quite a bit of time that they spend outside of the US throughout those 6 years. That require evidence, of course, to show when the person came in and when the person came out, but it can be a saving grace for certain H-1B employers and employees who are running out of time and for some reason cannot extend the visa anymore, but have some time to recapture. And one more word about status. Status is maintained while the person who is here in H-1B is working as per the instruction of the petition. If the person is not working or is not working for that employer or in that position or with these, or with significant material changes from the petition, the person is in status violation. They don't yet accrue unlawful presence, but they violate their status. And that can come back to haunt a person if it comes out in quite a few situations and might have a really adverse effect. H-1B, unlike J-1 and F-1 that have 30 and 60 days of grace period after completion of the program, doesn't have any grace period. So a person whose employment ended, terminated, has 10 days usually to wrap up their affair and leave. Those 10 days are only for days before departure, and they also get 10 days to arrive here, 10 days before the employment starts. This is not intended as a period where the person can look for another job and so on. That should be done while the person is working. So it's very important. There is no grace period that allows um, the employee to sit idle until they can get new employment. One more thing that is not allowed, benching. Benching refer to um, periods where the employee, for example, is between assignment and therefore um, not productive, is sitting at home. In this kind of situation that happen in certain industries quite regularly, the employer still has to pay the foreign national for a full-time work because or part-time based on the petition because they are not allowed to have a situation where during the H-1B they stop the employee from being able to work. If they don't, even if they don't have work, they have to pay. If a person terminated early, H-1B employee terminated early by the employer might be liable for return transportation. So they might have to provide the foreign national the cost of airfare or whatever it is that they need in order to go home. It only relates to the foreign national, not to their family necessarily. But this is important liability, and those obligations are being enforced by immigration and by the Department of Labor.